And you're very welcome to episode 18 of the Fifth Court, a podcast on legal affairs presented by myself, Peter Leonard, barrister.
And myself, Mark Tottenham, barrister and editor of Decisis.ie.
And Mark, good to see you as always. And I better at this point give a mention to our sponsor, which we are very grateful for. This is, of course, Practice Evolve software, combining document management and accounting software, offering law firms a holistic practice management solution built with lawyers in mind. Well, last week, you will recall, we had a fascinating interview with barrister Stephen Hannafy, who talked to us about changes in the copyright law and, you know, based on the famous case involving Ed Sheeran. Very interesting.
Absolutely. And of course, goes back to the famous George Harrison, My Sweet Lord case and all of the issues of songs that sound very alike.
Yes. Yeah. But we all thought, is there anything new under the sun? But apparently it has to be new, doesn't it? It has to be original. It has to be original. Okay, well, on today's show, and I think this is our first show where we have a solicitor and barrister combo in studio. This is the first time we've done this, which is really cool. We have solicitor Aileen Curry and barrister Ciara Dowd, and they've come in to discuss the new assisted decision-making legislation, which was passed in 2015. This is to do with wards of court and enduring powers of attorney. The state has been a bit slow to implement it, but I think there's been reasons for that. We're going to discuss all that. Really looking forward to it. But first, we're going to discuss three cases which you have identified from the Decisis website. We're going to start with a family law case. This is a decision of Ms. Justice Moira Whelan in the Court of Appeal, and this concerned proceedings which took place in both Ireland and Pakistan. And there was also child abduction proceedings, so very serious matters. The Court of Appeal held that it could not intervene in circumstances where a circuit court decision had already been appealed to the High Court. That had been boxed off, so to speak.
Exactly, yeah. So this is a case where, as you said, there'd been litigation in both Ireland and Pakistan concerning this marriage. And the divorce proceedings were brought in the Circuit Court of Ireland, where the husband tried to challenge the jurisdiction of the Irish courts, and the Circuit Court confirmed that they were able to hear them. This was then appealed to the High Court, and the High Court again accepted that it had jurisdiction. But then there were further proceedings which involved child abduction and guardianship of infants, where the husband again sought to challenge the jurisdiction of the Irish courts to have granted the divorce. And this went to the Court of Appeal. And because when a case starts in the Circuit Court and appeals to the High Court, there is no further appeal except in very...
That's the end of the process.
That's the end, except in very exceptional circumstances. And so what the court here said, Ms. Justice Whelan said, that the Court of Appeal simply couldn't interfere with that decision, that was decided.
Okay, so a very clear ruling in that case. Okay, next to a curious landlord and tenant case, where the tenants were deemed to be persons unknown.
Yeah.
Now, who are they? This is a decision of Ms. Justice Aileen Roberts in the High Court. It's a case called Phoenix Construction Consulting versus Persons Unknown in occupation of 11A North Frederick Street. So it's very specific in relation to the location, but not the people involved. It concerned a building with 4 apartments which had been sold by a receiver to the plaintiff herein. So they were the legitimate owner of the property. I think they were seeking vacant possession, but there was still some people in there. They were trespassing. They needed to get them out, but they didn't know who they were. They were persons unknown.
So the person who had owned the property had bought it with subject to a mortgage, and as commonly happens when he fell into arrears, then a receiver was appointed, and ultimately it was sold to the plaintiff in this case. But what had happened was that the original owner had then let out 4 apartments to essentially asylum seekers, and from the judgment it appears that these were people who didn't have English as their first language, wouldn't have been familiar with the Irish legal system. And so in order to get vacant possession, the plaintiff had to issue proceedings against people whose names he didn't know, as well as against the former owner. Now, there had been some attempt by somebody to effectively represent them, certainly by way of email, but it was an anonymous email claiming to represent some of the people in these apartments. And what happened was, so the former owner tried to have the proceedings struck out as an abusive process, and the court wasn't accepting that. They said that it was a perfectly legitimate claim to make. They then, an injunction was granted to the owners of the building against the persons unknown, requiring them to or restraining them from trespass. However, they also extended time for these people to enter an appearance, notwithstanding that there had been somebody who had already got in touch with them via this email saying they wanted to defend the proceedings, but no appearance had been put in. So effectively, she was saying, well, if somebody does want to put in an appearance,
so she left it slightly open-ended.
She did. She left the litigation open-ended, but the injunction is in place. So clearly,
and how do you give effect to that? I mean, is it just you clear the building? I suppose that's it.
Well, you by application for contempt of court. I mean, basically, you then need to go down the line that's in the Enoch Burke case, where you seek to
they're in breach of a court order.
Absolutely, exactly, yeah.
Absolutely. Okay, really good, Mark. Really good. Finally, a very interesting case in the world of communications regulation. Our ComReg for short. This is the case of 3 Ireland Hutchinson Limited against the Commission for Communications Regulation. This is a decision of Mr. Justice Maurice Collins of the Court of Appeal before he moved up to the Supreme Court. And this case concerns access to the mobile phone network, the spectrum, I think they call it, and a regulation that prevents any mobile phone company from owning more than 30% of the network. Now, it appears 3 Mobile were challenging that ownership cap. They felt maybe they wanted a little bit more than that, I think. But there was an auction for positioning on the mobile phone spectrum, and they were saying that has to be paused until they get a decision whether they're entitled to more, greater allocation, all that sort of stuff. I'm going to stop here, let you talk about it.
Well, it's a very complicated case, and I won't pretend that I understand all of the issues involved here. I doubt if anybody does, to be honest. Basically, when it comes to awarding mobile phone licenses, there's a very technical and very complicated auction procedure that is undergone. I think this is sort of the game theory that's originated in Chicago, where they try and get the best price for the state. So ComReg is in charge of this. But as part of this particular auction process, they introduced what they called a spectrum cap. So effectively, it means that no one company can own more than a certain proportion of the spectrum, which I think was 30%, as you said. Now, 3 Ireland apparently now is the largest owner of spectrum in the country, the largest mobile phone operator. And so they were concerned that they shouldn't be limited by this so-called spectrum cap. And they challenged that in the High Court. And Mr. Justice O'Moore heard that case and had reserved judgment until the end of January. What they were then concerned about was that ComReg were continuing with the auction process, notwithstanding that this this judgment was expected, and they wanted to put a stay, which is effectively an injunction, on the auction process, and that stay was granted by the High Court, and so they appealed it to the Court of Appeal, and Mr. Justice Collins set aside the stay and said that the auction process could proceed, but that it couldn't be completed. It could go as far as making the decision, but the decision couldn't be communicated until after Mr. Justice O'Moore had made his decision in relation to the spectrum cap.
Wow, that sounds like an Irish solution to an Irish problem.
I think it does, but there was a reasoning behind it, because effectively once the auction had been completed, then it would have affected the
But what happens
the effect of the Brian O'Moore decision.
But if let's say in the Mr. Justice O'Moore's decision in relation to the allocation of spectrum, and he says no, you can't be limited to 30%. Does that not have an implication for this other? Because the auction has already been determined then.
Well, if the auction has been...
Sorry, maybe
I have to work this out. Yeah, but that was the issue before Mr. Justice Collins. He had to determine that.
All right, Well, thanks, Mark. Now, that's great. So we'll be back shortly with Aileen Curry and Ciara Dowd.
Discover Practice Evolve, your leading global technology provider of legal practice management, including case management, document management, and legal accounting solutions. We are dedicated to constantly evolving our software, and all our solutions are offered in the cloud. We connect software to improve productivity, while our focus on software competency ensures users are empowered to discover innovative ways of working. We call it software with a service. With Practice Evolve, law firms are more efficient, more profitable and knowledgeable. Discover more today at www.practiceevolve.com.
Silence in the Fifth Court.
So we're delighted to be joined in the studio now by Ciara Dowd and Aileen Curry to speak about the new Assisted Decision-Making Capacity Act 2015, which, although it was enacted over 7 years ago, is due to be commenced fairly shortly and effectively is going to replace the current provision in relation to both wards of court and enduring powers of attorney and various other issues. So I'm delighted to be joined by both of you here.
Thanks very much. Delighted to be here.
Thank you for having us.
So, Aileen, I know in the past you've worked for the General Solicitor's Office for Minors and Wards of Court, which, as you've explained to me before we came into studio, is the is what you described as the committee of last resort. So, if nobody has a family member or whatever to represent them when they're a ward of court, that would have been your job. Isn't that correct?
That's exactly it. So the General Solicitor would have been appointed if either there was no other suitable committee, or if there was, a conflict or some issue within the family,
sure.
The court would appoint the General Solicitor.
I see. And now you're in private practice.
Yes, I took the big jump into the unknown and set up a practice with my business partner, David Hickey, Curry and Hickey Solicitors.
I see. And Ciara, you have written extensively about the new Act, isn't that right?
Yeah. I've got a few articles coming down the line, and I've been kind of doing a lot of CPDs and lectures about it, just, trying to get prepared for it. And
because this is an area obviously that affects almost any solicitor who's dealing with property and a range of other issues as well, and particularly I think it's fair to say where people have early onset dementia or have already lost capacity, issues in relation to transfers of property and what happens to their property once they have lost capacity. Isn't that right?
Certainly, it covers a very wide range of areas and issues, and I think it's fair to say that it's legislation that could very well affect all of us at some point in our lives.
Yeah.
So it's not like a specific area. It could, cover anything.
And in practice, I mean, when you're dealing with, with either enduring powers of attorney or wards of court issues, are you dealing mainly with people suffering dementia, or are other mental issues relevant? I mean, I suppose issues like schizophrenia or whatever must occasionally come across your desk.
Certainly. I mean, I think dementia, Alzheimer's is probably the majority of our cases, but, in our practice, we would deal with quite a lot of eating disorders,
right.
Persons who are detained in various types of institutions. So there's a huge range of issues, acquired brain injury as well.
Sure. And this brings in issues such as medical treatment, involuntary medical treatment, where somebody effectively has to be blood transfusion or something along those lines, where
indeed, it's all part of it.
Where they're not in a position to consent. Right?
Certainly, yeah, absolutely.
So, Ciara, could you just outline to us what are the key decisions that are made in the new legislation in relation to, first of all, wards of court, and secondly, enduring powers of attorney?
Well, this legislation will abolish wardship as the decision-making regime for adults lacking capacity. And I think the problems with wardship are well documented and well rehearsed, that, people could completely lose legal capacity if they're deemed to be of unsound mind and incapable of managing affairs. And obviously that's, very vague language. It's offensive. And I think that it's it's inappropriate now in 2022.
Sorry, can you just tease that out a little bit? When you say it's inappropriate, I mean, there are clearly people who have lost capacity and aren't able to manage their own affairs. I mean, is it more than just the language being offensive? I mean, are there people who could manage their own affairs who are effectively being prevented from doing so?
I think there are very few people that are wholly incapable of managing all their affairs. And what this new legislation will do, it will bring in decision-making supports that are issue-specific. So rather than saying, that you're incapable of managing one set of affairs, therefore you're entirely losing legal capacity, as is the case with wardship, it'll say, okay, if you're incapable, or if you lack the decision-making capacity in relation to financial decisions or healthcare decisions, it will give you a decision support just in relation to that. So I think it's, the unsound mind language, but also just the notion of being incapable of managing your affairs generally.
I see.
Can I just come in there for a second? This is the 2015 Act, and it's only just coming into play at the moment, Ciara. Like, what has been happening over the last 7 years? Why has it taken so long for this to kind of be enacted and come onto the statute books?
Well, there's been amending legislation that they had to bring about just to fix various problems that were in the 2015 Act. And so that's been in the works, I think, for a couple of years now. I think that there is delays due to COVID, but it's on track now, and hopefully it'll be commenced, the first half of this year.
Yes, okay. And Aileen, as a practitioner in this area, I mean, is this going to be a game changer? Are there provisions within this piece of legislation that are going to make things easier from your point of view and assist people, with mental issues? Is it going to be progressively beneficial?
I think it is, insofar as there's a whole mindset change. So from a solicitor's perspective, we have to look at our clients in a much more holistic and a much broader sense. So gone is the day that somebody comes into our practice and they're, is a question mark or a doubt about the capacity, and we might think, oh, well, we can't do this because the person doesn't have capacity. There's a statutory duty now on us as practitioners to do whatever we possibly can to try and assist our client to make the decisions that they need to make. So we have to sit down. The guiding principles of the 2015 Act are hugely important. I would say that if I was to give one piece of advice to a solicitor in this area, is to print off the guiding principles, to learn them, and to have a copy there on your desk. Because when you see your client, you need to do whatever you can do to facilitate, to assist, not to influence, but to try and find out what is the crux of the problem. What does the person want to achieve, and how can we go about achieving that? And if that's, if that is to involve bringing somebody else into the meeting, whatever it takes to try and help the person to come to the decision they need. So we need to go that extra mile.
And in practical terms, is that going to be difficult? I mean, does that involve bringing in medical practitioners, family members, and that sort of thing? I mean, it sounds like, whereas in the old day, under the existing regime, you would effectively be saying, right, I think there's an issue in relation to capacity. The next stage is Woods of Court, or the next stage is to try and draw up an EPA to have somebody else appointed. Yeah,
or it may be too late, at that stage. Yeah. There is a duty on us to try and bring about what it is that the person wants, regardless of the fact that there may be an issue around capacity. So we must try, and we've now got, there's 5 different options within the legislation open to us.
Will you talk us through those, Aileen?
Certainly.
Please.
So as I was saying to Ciara before we came on, that the problems haven't changed. So sure. I think we need to remember that this is new legislation, and it's wonderful, and we're looking forward to it commencing. But the people are still the people that come into us. The problems are still the problems. We just have new tools to assist us in advising our clients. So I think it's important to remember that the enduring power of attorney legislation that we've had for such a long time now, that remains. It changes. There are certain, there are different responsibilities upon us that we need to register the enduring powers of attorney up front, as opposed to waiting until the person loses capacity. But enduring powers of attorney, they will remain in the new legislation. And we'll also have advanced healthcare directives, whereby a person can actually sit down with their solicitor and go through the various concerns that they may have for the future with regard to their health and how they'd like to be treated. In terms of decision making, there's mainly 3 tiers, is how it's described. So the first tier is making a decision. So it's sitting down and writing out an assisted decision-making agreement, whereby you literally are saying to your trusted person, I would like to make the decisions myself, but I'd like you to help me, to support me in making those decisions. So it remains the individual or the relevant person, as the person is described in the legislation. It remains the relevant person's decision at all times. It's just merely a support. So that's the first tier, and that's the one that I think you really need to try to see if you can make that work, because we're obliged to always try and seek the least restrictive tier open to us for our clients. So that's where we start with.
It's a very challenging area for solicitors, isn't it? I mean, there's a fine line sometimes where you're trying to give effect to what the person wants, but maybe you're conscious of the fact that the person is moving into an area where they don't know what they want. And therefore, there has to be some sort of intervention, and there has to be a trusted person. Like, how do you make that judgment? I think that's really, I did one enduring power of attorney case. It lasted 3 days in the High Court. Fascinating case. I learned so much from it. But it was to do with whether a will was justifiable, etc., and whether the person had the capacity to make a decision. And there was legal experts on both sides, and we got into a lot of cross-examination of legal experts. But I felt for the solicitors, the solicitor is the starting point, has to sit down with the client and, push it as much as they can to give effect to what the client wants, but all the time be slightly conscious of the fact that maybe the client isn't able to make decisions for themselves.
Absolutely. There's no doubt that there will be a real challenge for solicitors, but you have to take every person on, as they are. Every person is different. You have to spend the time at the very early stages in getting to know the person, knowing a little about them, about their background. It's very much a judgment call at the time, but it's issue specific. So you might very well be in a position that you might be able to help with regard to one individual specific area, but maybe not with something else.
Can I bring Ciara in again? I mean, the legislation that's brought in is obviously changing quite a lot in relation to solicitors' practice. Has it been modelled on legislation in other countries? I mean, is it based on international good practice, or what is the sort of where does the theory behind this legislation come from?
It started with the Law Reform Commission report. I can't remember when that was published, but that kind of looked at a lot of jurisdictions, including England and Wales, and the Mental Capacity Act there, and the Office of Public Guardians there, and that led to the Assisted Decision-Making Capacity Bill 2013, and then the law has changed since then, and it was amended quite a lot in the Oireachtas, and now it's been amended again by the 2022 bill. But I think it's incorporated a lot of learnings from the UK, and I think the jurisprudence from the UK, from England and Wales, will be really useful for practitioners as we apply it here, because there are a lot of useful similarities.
And in terms of what happens to what is currently the Wards of Court Office, at the moment, I think we have what's called the parens patriae jurisdiction, where the President of the High Court is effectively in loco parentis for anybody who lacks capacity. How is that going to change? Does the President of the High Court lose that role?
No, that will remain. And there's actually the 2022 Act introduced an interesting amendment to the 2015 Act to clarify that the inherent jurisdiction of the High Court in relation to persons lacking capacity will remain in relation to the treatment and care and detention orders. So it's really interesting, and it'll be interesting to see how that plays out and how that inherent jurisdiction interacts with the 2015 Act and that statutory framework. But the High Court will also retain jurisdiction in other areas of the Act, including organ donation, withdrawal of life-sustaining treatment, and appeals. And of course, the Wards of Court Office and the Wardship Court, which is the High Court, they'll be in charge of the review of wards, which will be taking place within 3 years of the legislation commencing, whereby all the Wards of Court are reviewed to see if they're discharged from wardship and into a support framework under the 2015 Act, or if they're just discharged generally from wardship. So,
Can I just come in there? I'm curious about that. Discharged from wardship, that's a big statement. Does that happen very often?
I might leave that to Aileen.
Yeah, Aileen, what do you think?
In the 14 years that I was working in my previous position, I think I came across maybe about four times. So very, very rare.
And it should be very rare, really, shouldn't it? Because the High Court has taken control effectively and will only take control if necessary. So therefore that situation is unlikely to be reversed.
Yeah, nobody should ever be in
four
wardship.
Still is it's a curious number.
I mean, nobody should ever be in wardship unless they need to be there.
Can you recall any of those cases? I'm curious as to.
I can recall them all. One of the most significant cases was of a lady with an acquired brain injury. Most beautiful young woman came from a very, very challenging and very difficult background. She had a large amount of money invested in the Wards of Court office. She was a feisty young woman and she was just incredible. She was able to speak up for herself and she had very strong opinions on everything. And when she came to me and said, that's it, I want to get married, I want to buy a house, and I want to have a baby. I said, right. So we went and she got reviewed, and right enough, the medical visitor came back and said, yes, you no longer meet the criteria for wardship. And it was such a great day. She in the intervening period, she arranged to have a trust set up. So she knew herself that she needed help. But I mean, who wouldn't need help with a couple of million euros? You know, I know I would. She had a trust set up. By the time we went to court, she came into court with her trustees. Everything was set up. It was a great example of how this could work, not just then, but for the future.
Very encouraging, actually.
It was super. And the same lady, in fact, I was at her wedding. So it was,
wow,
I was at her wedding. It was absolutely...
That's an attention to your client that goes beyond
and at that stage, the Marriage of Lunatics Act wasn't repealed. So it actually was even all the more significant.
Yes, even that word, the Marriage of Lunatics Act. I mean, it's not really acceptable in this day and age, Ciara, is it?
No, it's completely Victorian language. It's completely outdated, offensive, not appropriate. And so the use of the language in this act, decision-making capacity, I think it's more accurate and reflects, the nub of what we're getting at, that, people need assistance with.
Can I ask, does the act do anything to assist people who, shall we say, clearly have decision-making difficulties, but are a long way from having lost capacity? And I mean, this is something I've come across in practice, and I've heard other people discuss, where you have people who clearly make an awful lot of bad decisions, where they are under the influence of other people who they are giving money to, that money is going astray, and yet family members feel that they can't step in to do anything about it. There seem to be a lot of people like that. And, we come across, obviously people through the criminal courts who, for example, have addiction issues or whatever, who clearly, for want of a better term, have decision-making difficulties. I mean, does the Act extend to people in those sort of circumstances?
Well, the Act isn't specific about a diagnostic criteria, I'd say. It's about people that lack decision-making capacity or may shortly lack decision-making capacity. And it's unlike, the UK jurisdiction, it's not based on any medical diagnosis. So the lack of decision-making capacity could be for any reason. But I think important to note here is that the Act puts in place that people have a right to make, or I don't want to say they have a right to make an unwise decision. Nobody has, we have the right to make that, but there's consequences for that. But it says that unwise decisions are not evidence of people lacking capacity, merely for that. So
that's very important, isn't it? I mean, you have the freedom to make a mistake, and we all have that. So it mightn't be a wise decision, as you say, but that shouldn't inform whether that person can make a decision or not, I think.
Absolutely, not by itself anyway.
So it's up to the person effectively to decide for themselves whether they have decision-making difficulty.
Not necessarily. I mean, there will be, there's going to be general and special visitors under the Act that will make those assessments as well. And then the court will decide if somebody lacks capacity with a co-decision maker or without a decision maker. But But the Act, I think it's important to note that it's empowering and it's meant to maximize capacity. And so it is about, do people want to come under the framework of the Act? Do they want the assistance of the Act? Do they want the formal arrangements? So it's about their wishes, and it emphasises the will and preferences of the person, and do they want this kind of to come under this arrangement?
Okay, can I come in here and just ask more practical questions, Aileen? I'm throwing them at you here. But in terms of the enduring power of attorney, and you talk about the person who assists, what's the phrase? The
attorney.
The attorney.
Yeah.
The
donor
attorney.
and attorney.
Yeah, the attorney. Like, is there any difficulty in that situation? I'm thinking of, let's say, an elderly person who is a parent of maybe a number of children. You know, why pick one? Sometimes families disagree on whether the parent can make a decision or not. I have personal experience of this in terms of court. I have represented people in this area. I mean, you know, how do you work with that as a solicitor? The practical realities of dealing with people who have different views, and maybe and both are all may be well motivated, and their intentions are good, and you know they wish to do the right thing by the person who can't make up their own mind or isn't capable of deciding for themselves. So how do you get involved in that? Again, it's the practical solution.
That's been around forever. That's nothing to do with the new legislation.
Yes.
I mean,
yes, but I suppose I'm trying to get some tricks.
Okay, no, that's fine. So at the interview stage, so when we're meeting our client and having the conversation around creating an enduring power of attorney, well, I mean, the first question is, well, why do you want an enduring power of attorney, and why have you selected, you know, whoever it is, Johnny, as your attorney? Or like, we need to ask our client how they have come to the decision to select. You know,
but what happens if the client cannot make that decision? The client is now at a stage where the client is not capable of making their own decisions, can't inform you of this information. So you have the next of kin coming into the process.
I think we need to take a step back from that, because I think if I'm at a stage where my client is not able to inform me who they want to have as their attorney, well, then I'm really not in a position to enter into an enduring power of attorney. I think we I think if it's at that stage whereby we can't get the most basic of information in an EPA, has to be. And the most important decision is, who is that person that you trust so much that you want to make them your attorney under your enduring power of attorney? Well, I think if the person is, if they're at a stage where they don't have the cognitive ability to decide who that person is, well, I think I would be looking to the new legislation to see, well, you know, maybe we're past the enduring power of attorney stage. Maybe our dementia or Alzheimer's or whatever it is at a different stage. Now,
so it has moved on to wardship then?
Well, in today's, if we were dealing with it today, perhaps we're into the wardship, because today, obviously, wardship would be the next layer we would go to if we can't create an enduring power of attorney. But I think there's two different questions there. I think if the question is that, you know, if your client is at a stage that their cognitive ability is such that they cannot focus or decide on an attorney, that's one question. But if they come in and they actually can, but they're just stressed and agitated about which child or who to select, I think that's a different question. And I think then you have to dig down, you know, if you feel that capacity is not an issue.
That's where the skill of the lawyer comes into play,
well,
I presume.
You need to dig down as to find out why.
Fascinating. Brilliant answer.
And
really,
would you
really
ever
interesting.
recommend to somebody that they actually don't execute an EPA, that they might be better just letting the matter go to the Wards of Court office rather than select among a number of family members?
There's so much I want to say on that question. I think what I would do in that situation is, no more than yourself, we've had several cases of an enduring power of attorney that has failed, that has not succeeded. And I wouldn't want anyone to go through that. It's a horrible place to be, whereby you have created an enduring power of attorney and perhaps at the time you're creating it, your solicitor doesn't realise that in fact your two daughters absolutely are skinning each other alive. It's not going to change when your capacity goes. I promise you. It's if the problem is there at the creation stage, it only gets worse.
Yes. Happy families.
You know, it really
Absolutely.
does. So, you know, I think you have to give the example of, not to scare your client, but if they really have concerns at the beginning, I think it's important to explain that in our practice and in my experience, an enduring power of attorney that we have not been able to register because of a row in the family, it only it ends up in wardship anyway.
Okay, this has been illuminating. It's been really, really good. Folks, before we let you go, they're waving at us through the window. Unfortunately, we're running out of time. So, Ciara, I'm going to come to you first. We suggested maybe you might recommend a book, a legal book that you like, or a movie that you like. Do you want to take that one?
Yeah, no, absolutely. I think this might be on students' reading lists already, but if not, I think it's a great book, and it's Justice by Michael Sandel. And I think I read it soon after I left college, and I only regretted not having read it sooner. It's just a really accessible introduction to jurisprudence and different philosophers. And I think that all lawyers at the start of their career should be reflecting on what justice means to them and what they think fairness is. And it's a good habit to get into. So
yes, so that one. Okay, that's really interesting. And a movie? Was there anything that grabbed you?
I think Erin Brockovich. I think it shows,
campaigning plaintiff. Yes,
absolutely. The power and also the limits of the law, and the good that
great
can
choice
do.
Actually. Yeah, that hasn't come up before. That's a really good choice. Aileen,
a book. I am Amy Dunn. The Miss D case, written by Amy Dunn, with the assistance of Orla O'Donnell.
Oh, yeah.
And the reason that I choose that book,
the legal correspondent of RTE.
Yes, indeed.
Okay.
So this is the reason that I choose this book is that page 88, page 99. Amy says, "I felt my voice was getting lost, like I was invisible." So she goes through a couple of paragraphs describing what it was like to be that young, frightened girl, surrounded by lawyers in the forecourts. And I just thought we need, certainly in the area that I practice in, to remember what it's like to be the person who's the subject of the court and who's frightened and vulnerable. And I just thought her words were so powerful.
Fantastic.
Yeah.
Right. Okay, and a film?
No, I don't.
Okay,
That's not bad.
I'm just not a television person.
Brilliant. Okay, so thank you very much to both Ciara Dowd and to Aileen Curry for joining us here in the Fifth Court.
Practice Evolve, your legal technology provider, here to provide our users software with a service, incorporating cloud solutions, connected integrations, and encouraging user competency.
The Fifth Court will adjourn until next week.
So that's all from this edition of the Fifth Court. We hope you have enjoyed it. Can we say a huge thank you to our guests, Barrister Ciara Dowd and Solicitor Aileen Curry, for coming in and talking to us about the assisted decision-making legislation. Really interesting discussion there, Mark.
Yeah, absolutely.
Really good. And I'd also like to say a huge thank you to our producer, Conal O'Morine, and to the Dublin South podcast studios, and in particular to Peter Rice for recording this show and doing such a wonderful job. Mark, we can't leave without saying thank you to our sponsor.
Absolutely. We want to thank Practice Evolve Software, combining document management and accounting software, offering law firms a holistic practice management solution built with lawyers in mind.
Very good, very good. And if you have any comments or any legal stories you'd like us to discuss, please contact us on the website or on LinkedIn. And please share this podcast because we're still building up our audience. So for me, Peter Leonard.
And me, Mark Tottenham.
Thank you for listening, and we'll see you very soon in the Fifth Court.